Good afternoon, everybody. I don't know whether you can see us. Hopefully you can. Thank you for joining Paul and me to deal with Kenig and Thompson. It's not often that one single case alters the entire risk profile of a particular sort of litigation. And this case certainly has. And it's because of that we're going to go through the implications of this case in much more detail than we would ordinarily with any case of interest. And an appropriate starting point, I think, is the background, which will take me to the second slide. Paul Hughes is going to deal with the background. I'll deal with the core of the case, and Paul will then take you back to the conclusions of the Court of Appeal and what we can possibly draw from that. Over to you, Paul.
Thanks, Matthew, and good afternoon, everybody. Thanks very much for joining us on this webinar. The problem that the Court of Appeal wrestled with in Kenig is an important one. It's likely to become more important as time goes on for statistical reasons, above anything else, as well as obviously lawyers' interests in arguing interesting points. But the first point to consider is how we got to where we are. The problem that Kenig addresses is really a twofold problem. The first is where there is an executor who is administering an estate and owing fiduciary duties to the beneficiaries of that estate, and they pay scant regard to the costs that the solicitors are incurring, for which the beneficiaries of the estate will ultimately be liable because the executor is entitled to take money from the estate itself. The second is that problem, but writ large. So where a solicitor is acting as an executor and retains their own firm to administer the estate, charging what might, on the face of it, be seen as an unreasonable amount of cost, it is and must be in the interests of justice that beneficiaries who are owed a fiduciary duty by executors, whether solicitor executors administering the estate and appointing their own firms or other executors, it must be in the interest of justice for them to be able to challenge the fees that are levied. And so the question broadly as to whether the rights of when rights of third parties to seek assessments of costs for which they're liable is dealt with in Section 71 of the Solicitors Act. And what we'll do is note that after Kenig, there's an important distinction to be drawn between the two subsections. The problem has received wide media attention. The issue is being played out throughout the country. Back in 2009, there was 1.25 billion worth of fees in the high street banks and solicitors dealing with levied for dealing with the administration of estates. And as I indicated, those sums are paid out of the estate, leaving a reduced pot for beneficiaries. Apart from anything else, that's inimical to the administration of justice because it gives rise to an apparent collusion. If a solicitor is appointed as executor and appoints their own firm, then one might take the view that it appears unreasonable and contrary to common sense. The extent to which that is likely to increase was made clear in The Guardian just in February of this year. In that article, The Guardian referred to the ruinously expensive cost of Inheritance Act disputes or inheritance disputes in England and Wales. There are around about 10,000 or so wills disputed each year. And the reason for that is because we are at the thick end of the wedge with regards to baby boomers who are property rich, have a lot of property to give away. The financial price for dependents is higher, as well as, in fact, the Guardian reports a rise in dementia, giving rise to keep larger challenges for the wills being drawn up and actually they're not being drawn up properly. And so to the provisions. Section 71(1) of the Solicitors Act, 1974, provides for a number of key definitions. This is the section that deals with the entitlement of a third party to seek an assessment in relation to the party chargeable, to their costs for which they're liable, as if they're the party chargeable. A few definitions here then. Section 71.1, a person other than the party chargeable with the bill who has paid or is liable to pay. When you look at these provisions, it's important to keep in mind the difference between, on the one hand, a party chargeable with the bill, and on the other hand, a person who has paid or is liable to pay the bill. So that would be the third party. And that's a key distinction between the relevant important people for the purposes of Section 71.1. So Section 71.1 would generally cover a person who has a liability, so a third party who has a liability to the party chargeable by way of a contract. So, for example, a person who has given a guarantee, third party who's given a guarantee to the party chargeable that they will pay their costs, contractual guarantee, or a tenant who is contractually liable under the terms of a tenancy agreement to pay the landlord's costs. Another example being an insurer who has agreed under the terms of an insurance policy, again, a contractual liability to pay the insured's costs. So party chargeable would be, in those cases, the insurer, the landlord, or the person subject to the guarantee. The third party would be the person who have contractually agreed to pay those costs. That means that what happens in relation to these applications is that there's an application to the High Court for an assessment as if he were the party chargeable. Sorry, as if the applicant were the party chargeable. So effectively, the third party jumps into the shoes of the party chargeable, and that mechanism is also reflected in the order that the court might make. Subparagraph 1, the provision provides for the court may make the same order, if any, as it might have made if the application had been made by the party chargeable with the bill. So the jumping into the shoes into the shoes of the party chargeable is also carried through, or at least appears to be carried through, with regards to the order court may make. We'll come to how important that is and the way in which the Court of Appeal dealt with that in Kenig, and the distinction between Section 71.1 and 3 in due course. The only difference here in relation to a Section 71.1 application and Section 71 and a Section 70 application for an assessment is in relation to special circumstances, and that permits the court to take into account circumstances affecting the applicant, the third party, but not the party chargeable with the bill. So that's the only distinction between jumping into the shoes of a party chargeable. So that deals with the principal considerations in Section 71.1. We move on to Section 71.3, and that's the provision that we'll be dealing with today in more detail when it comes to Kenig. Section 71.3 provides for trustee, executor, or administrator being liable to pay the bill of the solicitor, so fairly self-explanatory, on the application of any person interested in any property out of which the trustee, executor, or administrator has paid and is entitled to pay, then the court may order. So the first definition now, the distinction between 71.1 and 71.3, is that these applications are not made by a party other than a party chargeable with the bill, but a person interested in property out of which the trustee, executor, or administrator has paid or is entitled to pay. So it requires an interest in the monies out of which the costs are being paid to the solicitors. Now, the obvious example of that is the beneficiaries of an estate, and because their interest is plain, they are the beneficiaries of an estate, and the executor or administrator pays costs out of the estate, so they have, by definition, an interest. But there are others, so for example, where a creditor has obtained a judgment in administration, they may seek an assessment of the bill paid by the deceased. They have an interest in the costs paid to the solicitors out of the deceased administration. The provision provides that the court may order, in this case, subsection 3A and B, that the bill be assessed on such terms, if any, as it thinks fit, and that payments payments in respect of the amount found to be due are to be made as it thinks fit. Now, that, on the face of it, is a broader, or appears to be a broader power than the more restrictive provisions in Section 71(1), which, of course, reflect the entitlements as if the party were chargeable. So, jumping into the shoes of the party chargeable here, the wording doesn't appear to be limited to making an order as if the interested party were chargeable, but as the court sees fit. The considerations on Section 71(4) of the Act are that, and this again, I gives rise to two particular points. In considering any application of subsection 3, the court shall have regard to Section 17, insofar as they're capable of being applied to the extent and nature of the interest of the applicant. So there are 2 points here in relation just again to the wording of Section 71(1) and Section 71(4), which applies to Section 71(3), but doesn't apply to the other. The fact that the court can have regard to the provisions of Section 17 rather than making an order as if the party were charged for an assessment, as if the party were chargeable. And secondly, it will have regard to the nature and extent of the interest of the applicant. So again, setting up what appears to be a broader test for the purposes of a Section 71(3) application. Now, however it was intended to apply in facilitating access to the assessment process for third parties, Section 71 has not been interpreted in a broad manner. That's, in fact, the effect of Section 71 has, in general terms, been, up until now, perhaps rather toothless. Now, that is because the party chargeable with the bill for purposes of Section 71(1) has almost always either approved or paid the monies. And so the party chargeable with the bill has dealt with their liability before it comes, and then the contractual indemnity that would be entitle the third party to challenge the bill because of the effect of CPR 46.93 and the presumptions that apply as a result of that section, which obviously you will all know, means that where there's express or implied approval of costs, then you're unable really to argue that the amount is unreasonable amount or unreasonable in principle. And because of that effect, in essence, any time that a party chargeable with a bill has approved sums that are due to the solicitors, the third party, the party other than the party chargeable with the bill, who is liable to pay the bill pursuant to the terms of the contract, will be effectively unable, subject to very limited exceptions, to challenge that bill. And that was made clear by this case in Tim Martin Interiors and Aiken Gump. And in that case, the company had borrowed money from a bank and had given various mortgages as a security for the loan. Those mortgages included a covenant that there would be a payment of the bank's costs in relation to the mortgaged properties if there were a default on the loan. Now, obviously, the company defaulted on the loan. The bank instructed solicitors at significant cost to enforce the mortgages and obtain possession. The company who had defaulted on the loan were left with a whacking great big bill, but they had to pay the costs incurred by the bank pursuant to the terms of the covenant, and applied for a Section 71(1) assessment of the costs. Now, the judgment of Lord Justice Lloyd at paragraph 95 made clear his view of the appropriate test. And he took the view that the cost judge, in such a case where a Section 71(1) application is made, would have to follow what's called the blue pencil approach. Now, this is in fact a huge restriction on the ability of the court to assess costs in any sort of broad interest-based manner for the reasons that I've given. What Lord Justice Lloyd said was effectively, you can't strip out sections of the bill based on excessive time or an excessive amount for for the reasons that I mentioned in regards to CPR 46.93, which applies if you're the party chargeable with the bill. So there should be no difference between the third party's entitlement to costs and the party chargeable with the bill's entitlement to costs, which means that 46.9 has to apply, and the same restrictions will apply as against the party chargeable, as against the third party, subject to two very limited exceptions. The first would be in circumstances in which the liability between the party chargeable and the solicitor as expressed in the contract that forms the entitlement for the third party to seek an assessment between the third party and the party chargeable is out with the scope. So where there's an agreement between the third party and the party chargeable that is narrower than the entitlement of costs between the party chargeable and the solicitor, then the third party will be entitled to rely upon that exception. In other words, there's a scope exception. So that is affected by the blue pencil test. The only other exception to this huge restriction, which is imposed as a result of the narrow wording of Section 71.1, is where costs between the solicitor and the client are only allowable on a special arrangement basis of the 46.93C. So what you'll know as the unusual costs. So, for example, the unusual costs provisions. So, for example, the case in which a solicitor didn't tell the party chargeable that the costs couldn't be recovered from the third party because they're unusual. The third party will be able to rely upon that special arrangement to reduce the costs. But that's it. And so the Court of Appeal in Tim Martin hugely restricted the scope for Section 71.1 to be utilised to obtain a fair assessment of costs. What Lord Justice Lloyd said in Tim Martin was that the alternative remedy was in fact that there should be a claim for an account, a Part 8 claim for an account, and then that would be referred to a master or district judge. The district judge would then order something akin to an assessment. That will be referred back to the account, and the amount that would be due between the third party and the party chargeable would be assessed. So it would be a quasi assessment, just as Lloyd said. However, that again, in practical terms, doesn't take place because, in essence, the executive only has to produce. So that in general terms doesn't take place because it's a bit of a circuitous process to achieve the same result. Now, those points were considered, and I'll pass back on to Matthew now to deal with Kenig. In the case of Kenig, and the distinction between 71.1 and 71.3 was brought to the fore, and in particular, whether or not Lord Justice Lloyd was right in Tim Martin's saying what he did. Thanks, Matthew.
Yes, and the upshot, of course, is, as you all well know, in Kenig, the Court of Appeal agreed with Costs Judge Brown that there is a material distinction between Section 71.1, Section 71.3, and the scope of the possibility of having an assessment, the scope of an assessment, and the scope of any remedy. The background was that Mr. Kenig and his sister were beneficiaries to the will of their mother. The solicitors were instructed by a sole executor to administer the estate, and the estimates of costs that were given by the solicitor of £10,000 to £15,000 were, as it transpired, very quickly and very substantially exceeded. So Mr. Kenig applied for an assessment. He came up against all of the arguments based on Aching Gump that Paul has just explained, and Costs Judge Brown didn't agree. He didn't agree that even if the argument had been correct, that he was constrained by Aching Gump, that an assessment would have been pointless. But his main decision was that the assessment provided for by Section 71.3 is broader than the assessment provided for under Section 71.1. His judgment in that regard, which is a very detailed judgment, was dismissed by the Court of Appeal. That was made apparent, and Paul's going to deal with the conclusions, but was made apparent early on in the judgment of Lord Justice Stuart Smith, who gave the only substantive judgment in this case, with which the rest of the court agreed. And he said at paragraph 10, it's plain on the face of section 71 that the third party applications under section 71.1 and 71.3 differ in these respects. A, the person who may apply for an assessment. B, the nature of the application which the applicant may make. And C, the nature of the order that the court may make on such an application. And to anybody who reads those subsections, as we just have done, that much is plain. And Lord Justice Stuart Smith went on, as Paul's just explained, that if you think about it, subsection 1 appears designed to deal with the situation where somebody is in some sort of contractual relationship with somebody who instructs a solicitor to indemnify them in respect of what they have to pay to that solicitor. Subsection 3, on its very face, is very different because it's not for that sort of arrangement. It's for the to protect the interests or to allow a remedy to beneficiaries who have an entitlement which is based on a will and on the expectations arising from that will, or otherwise from some sort of entitlement arising out of a trust fund. And the person chargeable, and the Court of Appeal was very alive to this, one of the very material differences is that in subsection 1, if you're a bank and the person who ultimately is going to pay is one of your customers who's given you a covenant to pay whatever you have to pay solicitors if you have to take proceedings because they default on the mortgage or the like, you take somewhat of a risk in that your customer might go bust and you've got no remedy, and you're in a much more difficult position than somebody who is instructing solicitors to administer an estate, because that person, that executor, who may be a professional executor, is at very little risk indeed if the ultimate beneficiaries can't challenge what that executor agrees to pay to the solicitors, because the executor can just take out of the estate whatever he or she is required to pay to the solicitors. In other words, put in colloquial terms, there is a very real risk that an executor who's a professional executor, if he or she doesn't take his duties seriously, could think, this isn't my money, I don't need to be so cautious in how it's spent. That's one of the reasons why, and the Court of Appeal agreed, that the nature of the assessment under section 71.3 is for very good reason looser. The Court of Appeal explained that in paragraph 14 of the judgment by saying this: the party chargeable in an application under section 71.3, quite apart from being entitled to pay the solicitor's charges out of trusts or estate property, owes fiduciary obligations to the third-party beneficiaries, as will usually be known by the solicitor. We're going to pause there, because you will see later in this judgment the fact that the solicitor knows this in turn imposes a higher duty on the solicitor, at least in practical terms. The interest of the third-party beneficiary under section 71.3 is therefore wider than the interest of the third-party applicant under section 71.1. Quite apart from there being a greater need to protect the third-party beneficiary because of the ability of the trustee or executor to pay the fees out of the trust or estate property. So, the beneficiary is owed a fiduciary duty by the executor. The solicitor knows that, and in reality the extent of the assessment permitted will reflect the fact that the executor is expected to comply with those fiduciary duties and the solicitor is expected to give advice and to act accordingly, knowing that that fiduciary duty exists. And it makes a real difference to what the solicitor must say to the client. And in a sense, none of this is new. This has been a hiatus where the rights available to beneficiaries have been constrained in recent times. But it wasn't always the way, at least as certain authorities show. And one from 1867 was in re Bran. And Lord Justice Stuart Smith recounted what the Master of the Rolls had said in that judgment. And it was this. In Kenig, it was said that where a client, not being a trustee, required work to be done that wasn't wanted or useful, when a bill came to be taxed, the client wouldn't complain. He'd be told, you ordered it to be done, you were told it was useless, and you must pay for it. That's to be contrasted where the client is a trustee, and if a trustee in that situation makes a similar request or the same request, despite being told it's useless or inappropriate, then this is what the solicitor has to say. It would be the duty of the solicitor to tell the client that the work was not required for the purposes of the administration of the trust, and that accordingly, he, the solicitor, couldn't put them in his bill of costs, which would have to be paid out of the trust's estate. So this is what that means, according to the Master of the Rolls, Lord Romilly, by whom Lord Justice Stuart Smith said later in the judgment he was bound. The executor says, I want you to do a piece of work for me. The solicitor, knowing what the proper administration of the trust requires, thinks it's too much of a luxury, or that it's unnecessary, or it's not appropriate, or it's unusual. The solicitor is then bound to tell the solicitor, well, I'll do it, but I can't put it in your bill. In other words, I will put it in a separate bill, which will be chargeable to you, the executor, and you will not be able to recover that money from the trust fund or the estate in respect of which you are acting as executor or trustee. And Lord Romilly went on and he said this. It then comes to this question, which is probably a question for now the costs judge to determine. And these are important words, it seems to me, and this is what the solicitor's going to have to think about. Is it proper, necessary, or fit for the administration of the trust that certain things should be done? One of the very significant effects of Kenig and Thompson is, it seems to me, that now an ongoing refrain in a solicitor's mind when given instructions by a trustee or executor is that that solicitor must give active consideration to whether it's proper, necessary, or fit, and I'll use my word, for the due treatment or protection of the fund concerned to do what he or she is asked. If it's not, the solicitor has to tell the client, well, you won't be able to recover that money from the fund on behalf of which you act. I am going to have to charge you directly. And what was being contemplated was that even if the taxation was pursuant to Section 38, now that's the old equivalent to Section 71(1), the beneficiary was entitled to raise challenges that would not have been open to the client or trustee and was entitled to raise them after the fees had been paid. However, the main significance of the case lies in the recognition of the independent interest of the beneficiary that goes beyond the client, that of the client and the client trustee. There was some confusion when dealing with this case, about how Section 38 and Section 39, which isn't mentioned here, were transposed into Section 71.1 and Section 71.3. And that led to some confusion later in Aiken Gump when this case, Brown, was referred to by Lord Justice Lloyd as one of the relevant cases. And it's not, because when Brown is seen as in its proper context, what Lord Romilly, the Master of the Rolls, was talking about was the precursor to what is now Section 71.3. And the point that he was making is that a beneficiary has an independent interest which goes beyond that of the solicitor's immediate client, and the entitlement in the statute to an assessment is mindful of that and thus allows the beneficiary potentially a broader assessment than a client ordinarily would be allowed to have. The only other case really of significance was even older, that was relied on by Lord Justice Stuart Smith in Kenig, was one called Hazard and Lane. And that predated even the 1843 Solicitors Act. This is a case that wasn't considered in Tim Martin, but the circumstances were that a solicitor's bill was referred for assessment on the application of one of two trustees and executors who'd been the solicitor's client. Now, they weren't behind this. The motivation came from the beneficiary, but the beneficiary on the legislation at the time couldn't bring an application in his own name. In the background, without the knowledge of the beneficiary, the bill had long since been paid by the second executor, and that executor refused to consent to the application, but the other executor did. And the issue before the court was whether the solicitor should be allowed to say that the trustees have now paid, they've acquiesced over time, and therefore there is no scope for this other executor acting in effect on behalf of the beneficiary to try and seek an assessment. And the Lord Chancellor of the time said this, and it resonates. It resonates now. There's nothing old-fashioned about what Lord Eldon said here. A solicitor cannot be allowed to interpose the payment of his bill of costs by a person in the situation of a trustee between himself and the parties, i.e. the beneficiaries, for whom he was at the time aware that the person who paid him was no more than a trustee, as here an executor acting for the parties beneficially interested under the will. In other words, just because the executor, who isn't the person who's going to be damaged by all of this, who isn't the person whose true interests lie at the heart of all of this, just because that executor has paid you, the solicitor, doesn't allow you, the solicitor, to rely on that fact to prevent those beneficially entitled from having their entitlements investigated by the court. Back from the 1700s, it seems to me that when we come later in this talk to talk about time bar, which is still potentially an open question, these words will come back to be of very great significance when dealing with that potential and whether or not the payment of bills can prevent an assessment by those beneficially entitled and the request for an assessment under Section 71.3. Lord Justice Stuart Smith then said this, and it seems to me he said it rather modestly. These are slim pickings. They do suggest and support that the inference and position of beneficiaries as a particular subset of third parties has long been recognised because they have interests that go beyond those of a normal third party to a solicitor's bill. Well, they might have been slim pickings in terms of the fact that he was only able to find two cases to rely on. But are they really slim pickings? In terms of the consequences of what he's relied on in his judgment, and he said explicitly that he was bound by Brown, it seems to me that they are far much more than slim pickings. And it seems to me that it's legitimate to ask this, and I think the answer is certainly yes. Will those so-called slim pickings lead to the court scrutinising the costs much more closely, having regard to whether the work done was, to use those words that we saw before, proper, necessary, or fit for the administration, having regard to the interests of the beneficiaries? And if you were to ask me, I think those slim pickings have that very significant consequence. And of course, once you recognise, we'll go back to the last slide for a moment, if you think, and if you agree with me, that the likelihood is that the courts now will much more closely scrutinise those costs, having particular regard to whether the work was appropriate for the administration and having particular regard to the interests of the beneficiaries, then the importance of the indemnity basis solicitor and client assessment presumptions contained at CPR 46.93 will become hugely more important. We all know what they are, and I can brush over them to some extent, but the presumption is that if the client expressly or impliedly approved them, then they will be presumed to have been reasonable in reasonably incurred or reasonable in amount, depending as the case may be. But they will be presumed to have been unreasonably incurred if the costs are of an unusual nature or amount, and the solicitor did not tell the client that as a result, the costs might not be recovered from the other party. Now, spot here an alarming parallel. I'm going to go back a few slides in a moment. Spot the alarming parallel between unusual costs and the solicitor not warning the client that the costs might not be recovered from the other party to what was said long ago, to what the solicitor was expected to say in re Brown, that a trustee asking a solicitor to do work that was not required for the proper administration would have to say that he wouldn't properly be able to put them in the bill to be paid out of the estate. There are very clear parallels there, and it seems to me that the two of those can combine together to put a very powerful pressure indeed on the solicitor to be very alert to any instruction to do any piece of work that can't be seen to be appropriate or not unduly luxurious for the purpose of the task in hand in administration of the estate. There was then a reminder to compound all of this pressure. There was then a reminder by Lord Justice Stuart Smith at paragraph 29 of his judgment of Herbert and H.H. Law about what is required for informed consent. It's necessary for solicitors to show informed consent to the incurring of the costs. The initial burden lies on the solicitor who wishes to rely on those presumptions. Once the solicitor does that, the evidential burden shifts to the client to show that, in fact, there was no informed consent, but the overall burden lies on the solicitor throughout. And that takes you back to what informed consent is. Put in very simple terms, if the client doesn't understand, or if the explanation isn't as full as it should be, there can't possibly be informed consent. The way I often see it is you have to say enough to give the client a sufficient enough appreciation of the landscape forming his or her options at the time. And if you don't, if the client can't see the landscape of those options, then the direction that the client takes is made without being able to see what other pathways could be taken, and it's very difficult to argue in those circumstances that the consent could possibly be informed. Said much more succinctly, than that by Mr. Justice Holland in McDougall and Boot Edgar Estekin, an old case now, not as old as the others, of course, that you're all familiar with. The crucial words are the solicitor must demonstrate a full and fair exposition of the factors relevant so that the clients, using my word, can reasonably be bound by the choice that they make. Going back to the first instance decision in Kenig, Cost Judge Brown had concluded that there were special circumstances to warrant an assessment, doing as he had to do, or having as he had to have regard to the provisions in Section 70 as applied between solicitor and client. He assumed that the bills had all been paid, apart from the last, over 12 months before Mr. Kenig had made the application, in circumstances where, if this were the client making the application, then Section 70 subsection 4 would have bitten, and the client would have been time barred. It would have been jurisdictionally impermissible to have an assessment other than a common law Turner and Palomo assessment, even if there were special circumstances. And Cost Judge Brown concluded that that didn't fetter him here. And that finding of special circumstances, it wasn't appealed. And it was based on this, and this is the summary of it given by Lord Justice Stuart Smith. But Cost Judge Brown based his finding of special circumstances on the scale of the discrepancy between the original estimate and the costs claimed, which he described as very substantial indeed, the speed with which the initial estimate was exceeded, the absence of information that either justified the discrepancy or came close to doing so, and specific matters in the bills that gave rise to possible concern. And you get the picture. We don't need to delve into what the specific matters were. And there are material differences between. This is the conclusions. I was running ahead of myself. Having found special circumstances, the Court of Appeal at paragraph 51 then dealt with its conclusions, and no doubt having heard enough from me, Paul will deal with what the Court of Appeal actually decided, starting from paragraph 51 of the judgment of Lord Justice Stuart Smith.
Thank you, Matthew. So, having run through the authorities and considered the treatment of the previous incarnations of the Solicitors Act and the authorities in Tim Martin, Lord Justice Stuart Smith, on the principal question as to whether or not the Court of Appeal, and this was ground one of the appeal, were bound by Tim Martin in respect of cases and applications that were brought pursuant to Section 71.3, the Court of Appeal came to the view, Lord Justice Stuart Smith stating with confidence that they were not so bound. And so they were not bound to follow Tim Martin, because they said with confidence that Tim Martin, for a number of reasons, they said with confidence, firstly, that Tim Martin clearly concerned the application of Section 71.1. So as a matter of precedent, anything that Lord Justice Lloyd said about Section 71.3 could be treated as obiter dicta, and therefore we know not binding upon this Court of Appeal. The Court of Appeal went on to say that any assumption by Lord Justice Lloyd that appeared from the judgment that there was no material difference between Section 71.1 and Section 71.3 was wrong, whatever the reasons for it. And they posited a number of reasons as to why there may have been this assumption, but didn't conclude what the justification for it was. And in any event found that it was wrong because there was no rational basis to transpose the principles in Section 71.3 to over to Section 71.1 over to Section 71.3, because the wording of the rule was different and the interests, the parties were different. What the Court of Appeal said is that there are material differences between application Section 71.3 and those under Section 71.1 because of the different nature of the interests of the third party and that the different subsections are intended to reflect. And the Court of Appeal, and Lord Justice Stuart Smith addressed that earlier on in his judgment. And in this slide, the Section 71, so Lord Justice Stuart Smith confirms what the consequences of that mistaken assumption are, and that is that the judgment cannot be relied as saying anything authoritative, in other words, it's obiter, about the position that obtains where an application and assessment are brought under Section 71(3). And so as a matter of precedent, they were not bound. Anything that Lord Justice Lloyd said is based upon the mistaken assumption. There's no rational reason to transpose Section 71(1) restrictive principles onto Section 71(3). And so Cost Judge Brown was correct to find that it was distinguishable and should be distinguished. That meant that the relevant principles were still to be derived from that judgment of Lord Romilly in re Brown. And it was that authority, not Tim Martin, but that authority which did address the relevant principles, and that authority which was binding upon the Court of Appeal. The Court of Appeal then stated the approach of Lord Romilly in re Brown permits a wider inquiry going to quantum as well as to scope, before going on to deal with 2 points. The first was a point about whether or not an application made after 12 months was time barred because of the provisions in Section 70. The second being a point about approval. Dealing with the first point, then, that the solicitors submitted that because some of the bills had been paid more than 12 months before Mr. Kenig made his application, that was a complete answer. And in relation to the assessment of those bills, because of the terms of Section 70, subsection 4 of the 1974 Act, which of course provides for an absolute bar in relation to cases in which bills have been delivered and paid more than 12 months before the application for an assessment is made. Although the Court of Appeal didn't address this because they didn't hear argument on it for the reasons that Matthew has referred to, and any conclusion should be provisional, they did say that the situation in relation to a beneficiary, the situation in relation to a beneficiary under Section 70 is different because the court is only Section 71 subsection 3 is different because the court is only required to have regard to the provisions of Section 70 as to applications by the party chargeable. So that can be contrasted with treating Section 7, any application under Section 71(3) in a way that we would treat it under Section 71(1), which is as if it is made by the party chargeable, in which case the Section 70 subsection 4 time bar might apply. And so that again was a distinction drawn by the Court of Appeal with regard to 71(3) applications and 71(1) applications. And they went on to say that it seems to me well arguable that different considerations may apply to an application by a person chargeable who will know when the bills were paid as contrasted with an application by the beneficiary who may have no such knowledge. And that goes back to the point that Matthew mentioned about the knowledge of the solicitors in the situation of executors incurring costs on behalf of beneficiaries to whom they have a fiduciary duty, but who will not have the sort of level of knowledge that solicitors have. That was not pursued in the Court of Appeal because they considered it was not open for them to argue. And so it wasn't decided, although as a subscript to this point, there is an authority called McElwraith and McElwraith. It's not on the slide. McElwraith and McElwraith, 2002, EWCA 1757, in which His Honour Judge Rich, sitting as Deputy High Court Judge, appears to deal with this issue. I'm not sure whether it was referred to the Court of Appeal in Kenig, but it appears to deal with this issue for the purposes of Section 71, subsection 3 applications, in which case there would be a binding precedent in the High Court, but not, of course, in the Court of Appeal. So the Court of Appeal could have decided it differently, but it wasn't argued in any event. So we're referring to it's referred to in Dr. Christen's book, Christen Cost, 3rd edition. The second point that the Court of Appeal went on to deal with was this point about approval and the breadth of CPR 46.93, the 46.93 presumptions. They said the question was raised as to what effect on 71(3) assessment there would be if the executor had approved the bills Solicitors said any approval would preclude challenge by the beneficiary, whilst Mr. Kenig suggested that it might be a material factor that no hard and fast rule should apply because of the beneficiary's legit different interests. And what mattered most was protection of the estate, might say, in Lord Romilly's words, what is necessary for the fit and proper protection of the beneficiary's interests, interposing Matthew's parentheses there. The Court of Appeal, in relation to those two submissions, firstly accepted the claimant's submission, also Mr. Kenig's submission, that the ultimate interest protected was that of the beneficiaries. And not only because, in principle, that's the way in that's the interests of the beneficiaries were the ultimate interest to be protected, but also because of the wording of Section 71(3) with regards to who payments were to be made to or by, which indicated, given that the provision provides for the solicitor or executor, administrator or trustee, suggests a broader discretion. And thirdly, for the third reason for preferring Mr. Kenig's submission, is with regards to separate consideration being given to the position of the beneficiary and estate in circumstances in which Lord Justice Stuart Smith said there is no risk carried by the executor or trustee because of their ability to pay the solicitor out of the trust property. Finally, the Court of Appeal referred back to authority of In re Brown and Hazard and Lane, allowing the beneficiary to challenge the bill even though the executor approved it. And those are those points that Matthew referred to at an earlier stage. The kicker, however, comes at paragraph 58, and that is that even though the submissions of Mr. Kenig had been preferred, they did accept the fact that fully informed consent is likely to be a major consideration, which in many cases may prove to be determinative. So whilst approval, whatever that means, or express or implied approval or informed consent is likely to be a major is likely to be is not likely to be a bar to the right to the beneficiaries to seek an assessment in 71(3). It might be, or it's likely to be in many cases, a major consideration. And it's here that we're likely to see the battleground. So to conclude, thank you all for listening and take some questions in the room. One of the point, if there are any, one of the two sort of points with which I leave you are firstly, with regards to future conduct. Lots of solicitors, as Matthew mentioned at an earlier stage, will consider how you take instructions, information and estimates that are provided, whether or not if those matters are appropriate and can they be justified for the proper administration and protection of the beneficiaries' interests, and the extent to which informed if those costs are deemed to be unusual, the beneficiaries need to be told that they won't be entitled to recover it from the estate. The issues which are latent are those bills which are already out there, many of which will have been paid, and there may well be a resurgence of interest in obtaining orders for assessment of those costs, particularly because of the ever-increasing burden on the courts of these sorts of cases. Matthew, I don't know whether you have any concluding remarks, but those are mine.
Oh, well, yes, there is a time and a place for a glib, entertaining presentation with slides with funny AI-generated pictures on. This is quite deliberately not one of those presentations, because the situation that potentially is created by this case is extremely serious indeed. If you take into account the climate at the moment, the fact that the legal ombudsman set out an ombudsman's view of good service last year, with all the expectations in terms of estimates, quotations, updates on costs, if you combine that with the implications of Herbert and H.H. law and the requirement and the burden in terms of demonstrating informed consent, and if you combine that with Brown and what the Master of the Rolls, Lord Romilly, said about what the solicitor has to say to the executor if the solicitor considers that the work just isn't necessary for the administration of whatever the fund is, then you will see that the burdens placed on the solicitor by this cumulatively are enormous. And this is a very serious situation indeed, both in terms of the duties that the solicitors hold and the risks that they are exposed to, really, quite frankly, no matter how hard they try to comply with them. If there are any questions, yes, we'll attempt to deal with them. I can see that we're at 2 minutes to 5. If you want a copy of these slides, I've no doubt that Katie will send them to you. And apart from that, thank you very much for joining us. We'll look at the questions now. I can see that there's 3. Paul, can you see what they are?
I can't actually.
I can see. I've got one. As a US attorney, I sometimes see cases where the court must decide if a third party, i.e. not a party to the attorney-client relationship, can sue the attorney for malpractice. Will beneficiaries be a good example? Under UK law, what kinds of people or other parties are considered normal third parties in these costs dispute? Well, for the purposes of this case, they're always beneficiaries because that's what this case is about. And now that Kenig is out, I can, first of all, the first stop will be an assessment. But secondly, I can see that the, first of all, now that the picture is clarified somewhat, I can see that professional executors and solicitors potentially are both in the firing line. I don't know what you think, Paul.
Yeah, I agree with that.
Next question. Do you think the obligation on the solicitor acting to advise the executor that work might not be recovered extends to a value charge applied in addition to an hourly rate charge, such that a beneficiary can challenge the value added element? The executor could and should have tested the market for solicitors who would act without a value charge being added to an hourly rate, as otherwise they're not acting in the best interest of the beneficiaries and losing the beneficiaries' money. I entirely agree with that. The proposition in the question, I entirely agree with. And it leads me to really the rather uncomfortable position that you are presented with by the present climate. And I said this at a recent talk when I was dealing with hourly rates. Quite frankly, and some solicitors do write this in their client care guides, you need to be telling, as the BBC does, you need to be telling your clients that there are other services available, that they might be cheaper, and that they need to be taking a look. Again, Paul, what do you think?
Well, I agree. I think that's the same question in the context of a different charging mechanism. That's all. I don't think that there'd be any special considerations that would apply just because the nature of the charge is a value charge plus hourly rate. The question in every case will be whether or not, well, if you're right, Matthew, the question in every case will be whether or not it's an appropriate charge to be borne by the estate.
Yes, and going further, I suppose, the solicitor, him or herself, needs to know whether the application of a value charge is within the normal range of charges available in the market. So, and I'm sure lots of solicitors do know what their fellow solicitors charge, but there's a very specific reason why here as well. Next question. Is a solicitor required in every will or trust administration matter, or do these costs arise only when a particular issue requires a solicitor in a given case? Well, that gives rise to another question. The answer is no. It can be quite a faff, quite frankly, once you've been trying to get access to these utilities businesses and trying to close down accounts and the like when everything's on a call centre and people don't reply to emails. It can be an awful faff to administer an estate, but lots of people do it. Lots of lay people do it. They don't always instruct solicitors. And I suppose it gives rise to the question, if the solicitor thinks that just with a little bit of a nudge and a little bit of guidance, the client can do this for him or herself without paid for assistance, is there a duty on the solicitor to say so? What do you think, Paul?
I don't know. Yeah, I'm not sure. The question as to whether or not there's a duty on the solicitor to effectively refuse work and, or rather guide the client in a way that they might not previously be required to is probably an interesting point. Obviously, the question as to whether or not solicitors are needed to administer estates is one that won't be relevant. Well, if solicitors aren't instructed, then Kenig's not going to be of any application. But I generally agree with what you say about the fact that lay people can deal with this. I suppose it all depends upon the nature of the estate. Some are more straightforward than others, and obviously where there's difficulty, the legal profession are there to help or not, depending on what we view of Kenig is.
Final question. If I'm following this correctly, does this mean that there is, in effect, no time limit for a beneficiary to challenge a bill, even if it's been paid and approved by an executor? Well, I think for the moment, the answer to that is that pursuant to McElwraith, that Paul mentioned in his talk, if a particular bill was a statutory bill, a final bill for the period concerned, and if it was paid more than 12 months before the application was made, there is High Court authority to say that the beneficiary cannot, but there is a very large question mark about whether or not that authority will prevail.
Yep, that's right. Well, the Court of Appeal might decide differently, but that I think that question currently is dealt with. I suspect the point will find its way to the Court of Appeal because they've almost invited it by making reference to it and bringing their view on the considerations that are to be borne to such an application, but not deciding it. So I suspect that point will come before the Court of Appeal again.
It's now 4 minutes past 5. We've dealt with the questions. Thank you very much for joining us both. It's Wednesday. The weekend will be here soon. And I don't know why, but as Paul was just speaking, the ending words from Crime Watch or something like it just came to mind. And I'll leave you with this. These things don't happen all the time. Sleep well.